Welcome to the April 25th, 2019 meeting of the Zoning Hearing Board. Would you please join us for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We have two continuance requests to deal with first before proceeding to those cases that we will hear this evening. I'm going to call appeal number 3039, the Brothers of the Order of Hermits of St. Augustine. There is a continuance request before us in regard to that appeal. Counsel for the applicant here?
Yes. Nick Canolia representing the applicant on this matter. On Wednesday, I believe it was, or late Tuesday afternoon, about 5 o'clock, I received an email from an attorney who is representing several of the neighbors involved in this. He requested that we continue it so we can discuss certain matters regarding it. I agreed to it. That's the purpose of the continuance. I know there's also other neighbors that are interested that I believe are unrepresented. In the back there, I put down several exhibits because I believe there's some misinformation going on as to what the request is and who the applicant is. So I put back there the application, if anyone in the audience is interested, the application, the description, the novitiate, which is what they would be doing in the home, as well as the mission statement of the Augustinians. So that is back on the table. I also put a list if people want to sign and put an email down so we can talk to them later. And also Father Horn is present here if they want to talk to Father Horn this evening as well.
Okay. All right. We're going to approve the continuance without exception or without discussion. Thank you. The next continuance request is for, appeal 3029, the applicant Villanova University, property at 800 Lancaster Avenue, Villanova, P1 institutional. And this is a joint request for a continuance, and counsel from both parties are with us. Gentlemen?
Yep. Nick Canolia for the university.
Peter Nelson on behalf of Radnor Township.
I will go through, I have a timeline prepared that I'll go through as to how this progressed and how we got here this evening. Back probably around, I don't know, Kevin's around somewhere, but back around November, Kevin sent an email to, I believe it was Chris Kowalski, saying that he has some concerns about the usage of the stadium lights. We met with Kevin mid-November, and we said, and we knew the Board of Commissioners were discussing this matter. There was some concern. Area people were coming in expressing concern with the Board of Commissioners regarding the stadium light usage. We agreed that that email that you have as an exhibit would serve as an enforcement notice, although it's certainly not an enforcement notice, but we agreed to treat it like an enforcement notice to move the case along. Both Villanova and the township wanted to move the case along to some sort of resolution, whether it was by this board or by agreement. Back in December 18th, I had spoken to Mr. Rice, the solicitor for the township, and we agreed to continue it and to start discussions regarding a possible overall settlement agreement on the whole matter. John and I have spoken several times about it. All I'm going to go through are the actual meetings that we had regarding it, and bear in mind that not only are there layers at Villanova, but certainly there's layers at the Board of Commissioners level too, among which are the fact they only meet at most twice, if not only once a month. So we did continue that hearing from December 18th. We met with the township and their representatives on January 10th. Villanova had their own internal meeting with their consultants on January 14th. After that meeting, we requested another continuance from the January zoning hearing board, again, mutually accepted by both parties on this matter. Then after that, January 31st, Villanova again met with the township officials, myself, chief counsel, other Villanova officials, met with township officials, discussed an overall parameter for a settlement on this matter. On February 7th, myself and Villanova's chief counsel met with Mr. Rice again to talk about an overall settlement. We had another meeting on March 6th to again discuss terms. An initial draft was prepared by me on March the 20th of a settlement agreement. We then requested another continuance right prior to that on March the 19th, knowing that we were going to be in discussions for this. You may recall that there was two hearings at that time. One was April 4th, and then this one for this evening. I had mentioned when we asked that for a continuance last time, and Mr. Martin pointed out that I said it's probably unlikely that we're going to have everything ready by March the 4th, considering when the commissioners actually meet. On March 19th, I filed another request, or I believe Mr. Rice actually filed a request for continuance from the April 4th meeting. On March 24th, we received township revisions back to the settlement agreement. On April 2nd, I sent our revisions back to the settlement agreement. On April 17th, I had further comments, among which were specifics about the positive action that Villanova would be taken. And then on April 22nd, I received the township response, which was the last Board of Commissioners meeting on April 22nd. We still have some open issues, not many, but we do have some open issues. We're hoping that we can resolve it. And for that reason, we are requesting continuance. At this point, I know the townships only has one commissioners meeting in May. I believe it's May 20th or May 22nd. I believe at that commissioners meeting, they want Villanova to present some discussion to the board regarding what positive actions they're going to be taking. So I can't, it's unlikely that we would reach an agreement by that meeting. And then in June, I believe there are two meetings in June, one on June 10th and another one on June 24th. Unfortunately, the next meeting of the Zoning Hearing Board is on June the 20th, which is right before that June 24th meeting. Unless Mr. Nelson disagrees, you know, I would prefer if the board would deem it appropriate to continue this until the July zoning hearing. Certainly understand if the board wants to do it sooner than that. But again, I believe in that instance it would give us sufficient time. Recall also that school and commencement, I believe, is in early May. There are some camps that would possibly be using lights during the week. You know, but again, the agreement, we have already sent our schedule to the township regarding that possible usage and agreed that those lights would be turned off by 9 o'clock. So that's where we stand.
Mr. Nelson?
Not to add much to that. You know, the township's position that we think this continuance is completely appropriate and necessary for us to continue the negotiations with Villanova to resolve this amicably. Villanova has provided us with a large amount of information about what they're planning to do with the lights, what they're proposing to do with the lights, and the township needs time to review these, not only by its staff and its consultants, but also then to present that to the Board of Commissioners. As Mr. Cornelia said, there is a plan to have a presentation done by Villanova in May. You know, it's going to, you know, we have two large organizations with a lot of people that are involved. It takes a lot of time to work these things out. These are complicated issues, they're important issues, and we want to make sure we get it right. That's why we've been asking for these continuances all along, because we don't, you know, we feel if we can work this out, and therefore you guys don't have to listen to hours of testimony on something that we then resolve, we think it's better for all the parties. Township has no issue with this being continued to the July meeting, if that makes the Zoning Hearing Board more comfortable. If you're tired of hearing these continuances at each meeting, we're fine with that. If you want to have more, oversight into seeing how things are proceeding, we can continue, asking for the written continuances. I would just request maybe in the future, if we can just have the written continuances and not having to, come down here at this time.
I know the board, members of the board have questions. I'll speak to that last point. And I thank you both for appearing this evening. It likely would have simply been a written continuance had the solicitor not asked at my request to have you both here. This is a matter, and others will touch on this, which has been ongoing for a significant period of time, and it is also a matter of public interest. To the extent that there are members of the public that are here to keep an eye on this proceeding, I will request any thoughts from them when we get to that point. But I believe I wanted to see that there really are good faith efforts to try to resolve this, because just doing things in written form, I mean, we're attorneys. We get, how all that works. But given the fact that, as Mr. Cornelia indicated, there is some history to this proceeding, I thought it was appropriate to have you both here today, and I appreciate you for coming. Questions from the board?
Yes. Could you give us a sense of the two tracks this takes procedurally? I understand that in the absence of agreement between the parties, at some point you would be before this board on the appeal that you filed in mid-November, right? If there is a resolution, are you back in front of us or not?
We may be back in front of you. I think we have to kind of determine how that works. We would probably present the settlement agreement to you, hope for approval on it. But I believe we probably would be back before you, even if we do have a settlement agreement. Or unless we can, the way it's working right now, that's probably what is going to occur.
So what I'm hearing is that what would happen is you would be proposing a change in the current scope of the land use relief the university has, showing that the requested change is with agreement from the township. Is that a fair way to put it?
Yeah, I think actually to tweak that slightly, I think the change is actually to the relief. The relief was to the 50-foot limitation on the height of the lights. Villanova had asked for 100, and that's what I believe was granted. The whole questions now revolve around conditions to placed on the granting of that relief and promises made by Villanova in that hearing regarding the operation of the lights. So the end result's probably the same, but if you want to get specific to legally, we're not looking to adjust the relief. I don't believe the lights are being changed height-wise. It's more as to the operation of the lights.
And just to make it clear.
I'm sorry, which begs the question of whether we're in the business, I mean, that agreement would still need to be approved by the Board of Commissioners, correct? So in some respects, whatever we might happen to do vis-a-vis the settlement agreement that's presented to us, it's of no effect unless the Board of Commissioners also approves that agreement, correct?
Correct.
So then the question comes to my mind, are we just providing advice? Or are there, is there something within our jurisdiction under the MPC that permits us to do what you're asking us to do? But I guess that'll be a question, I suppose, when we have a settlement.
We really have to discuss that further, myself and the solicitor's office. And
it strikes me that if the citation was sent in the middle of October, I'm surprised to be hearing on April 25th or 26th, whatever today is, we have to discuss that.
No, just so the board's aware, Mr. Nelson made some statements. We don't agree that there's conditions on this approval outside of the fact that 6 light standards and whatever, but I really don't want to get into that right now. Remember, though, and I think, Mr. Martin, you would agree, the email sent by Kevin really is not an enforcement notice. We wanted to
You
move
appealed it.
Yes. we
So
wanted to move-
presumably you waived that
no,
argument.
we wanted to move it forward. We wanted to move it forward to get it before both this board and the Board of Commissioners because there was a lot of consternation over the use of the lights. And
Let's
both
talk
parties
about-
agreed to move it
Let's talk
forward.
about the consternation for a little bit. From the time the citation was issued until now, how, if at all, has the university altered the manner in which the lights have been used?
We have provided the township with provisions as to how the lights would be used during the period of the appeal. And they actually have, during the summer, they also have a list of possible, of usage as well. And that's why I mentioned in that list is the fact that lights would not be used after 9 o'clock during the summer. As I mentioned, it's really for summer camps and probably some for commencement. I do know there's a women's lacrosse game Friday night. So,
And in terms of the camp, is there any challenge with the argued limitation of Monday through Thursday?
there, I'm not positive if that's just
Okay,
Monday to Thursday.
and
I
that
just
gets
don't know.
back to my problem. And that gets back to my problem with the township. The township says that they're using the lights in a way which is illegal. Now, we're trying to figure out if that's true or not, but they're continuing to use the lights, arguably in a fashion which is contrary to their land use rights, since the middle of October. We're now 8 or 9 months into a process. We're hearing you want 3 more months for a process. If somebody was saying, school gets out early May, we'll turn the lights off, and we'll leave the lights off until we get this settled, fine. I don't hear that. What I hear is, we'll think, we'll consider, we'll try, but bottom line is they're going to use the lights the way they want to use the lights. And I think we have a right to figure out what their legal rights are. And I'm at a loss as to why this is dragged on. I'm just at a loss. The email was the middle of October. Your first meeting was January. Your first draft is March. From March to July to come up with this?
Bill, there was at least 5 face-to-face meetings plus numerous phone calls,
They settled
regarding
with
that.
North Korea in less time. I'm done, but I'm against the continuance.
Any other questions?
Do
from the board?
recall,
I'm sorry, I'm not done. I'm
one
sorry.
other thing, Bill, just,
No, I'm not done. Let me ask you this. In prior cycles, as we've had continuance requests, you have an email list where you've blasted out to folks, we're going to have a continuance, it's going to be a certain date. We commit to us that if it turns out that you don't settle and we have a hearing to try to resolve this, that you'll use the same email list to put out an email to the neighbors to say, this matter has not been resolved, it'll be determined by the zoning board at the blank meeting.
certainly, and the reason we didn't give that blast today is, unlike last time, is we did not have the continuous prior to the hearing. And remember, I think we both agree that this settlement will be good for everyone involved if we reach it, both the township, the neighbors, and Villanova. It is a township's enforcement notice. They're in agreement to delay proceeding on it. They're satisfied regarding the limited usage of the lights during the time period. And hopefully we'll resolve it. I mean, we're still,
Mr. Martin, if I could add to that, one of the things, because of the length of time that this has gone on, while the nature of the advertisement has not changed or would not change, should this come to this board for consideration, I would request Villanova to re-notify the mailings and resend the mailings to all the properties within 500 feet so that there's a clear indication that this is when it's going and not just rely on email blasts, that there would be a mailing as well as what was initially done for the initial appeal. That would be something that I would be looking to
we have
push
no
forward.
objection to that. Actually, I think we did it a couple times prior to that.
In terms of the schedule, you had mentioned the late May meeting of the commissioners, and there's a request for a presentation. Is the idea that the presentation, that a vote will not follow the presentation if all's well, that it-
I don't believe it would, but I don't, that would be,
My understanding is the presentation is to understand what Villanova is proposing to do physically out there with the lights and how those changes would address some of the concerns by the township and the neighbors. And yeah, I think it's partly to bring the board of commissioners up to speed and understanding of what's going on. It's also to allow all the neighbors and the residents to hear what's going on and to voice their opinion, since it's a public meeting. But you know, we don't want to promise that a vote's going to take place and not take one. So I suspect probably we will not have a written agreement ready to go because there are going to be changes made to that agreement based on the presentation and the board's reception of it.
why doesn't the township just dismiss the complaint?
Because like you said, there's been concerns and there's problems with it, and we want to keep the pressure on Villanova, and we think keeping the complaint there provides that pressure.
Thank you.
Yeah, I'm sorry, other, George?
I would ask our council to look into the issue about our jurisdiction to the extent that they do have a settlement agreement, and what's our function in that.
We'll certainly do that. At
whether
this
that-
point, it's hypothetical, but
Yes.
I'll certainly look into it,
At some point.
of course.
I believe that if parties to an issue are engaged in good faith discussions and feel that it's an appropriate request to have this matter continued, I would generally be in favor of that. My concern is, frankly, and I understand the schedule that everyone laid out, this town empties out after schools close. And continuing to the July, if you will, zoning hearing board meeting is, I'm not convinced you need all that time, even on the schedule that you guys laid out. And we don't meet in August. And we've heard the history of this matter being continued. I would be in favor of a continuance until the June 20th meeting.
Which
And-
is perfectly fine with the township.
Yeah, I mean,
What's the date of the board meeting in June? Do we know? So it would be before our meeting.
The next two meetings are
Yeah.
June 20th and June 10th.
So theoretically, if after your May presentation, if they didn't vote at that meeting, theoretically, they could vote at the June 10th meeting. Theoretically, it would be a signed agreement if we need to look at it at all.
Correct.
At our meeting in June.
but then that gets back to Bill's question about process and who has to look at something first. I'm assuming if we look at it at the June meeting, the commissioners meet in July, don't they?
Correct, yes.
Okay.
I think it is the parties' plan to come to an agreement between ourselves that has been fully approved by both the Board of Commissioners and the appropriate people at the university, and then present that to you. Now, and you then, depending on what your solicitor determines, obviously, if your solicitor determines like it's outside of our jurisdiction, it's outside your jurisdiction, and we'll deal with that. The reason why, if we present it to you, the reason why we are presenting it to you is we think it's actually within your jurisdiction, that it's something we have to present to you, that it's not like we're doing it just to drag this out or to waste your time. It's
No,
because
I
we
wasn't
believe-
suggesting that. It's just
we believe
without
It's
knowing.
important. It's interpreting your decision, and we believe you have the final say over that, and that's why we plan to present it to you.
And without knowing what might be in any settlement agreement the parties might agree to. It's hard. Yeah, I mean, we're all in the dark, so. Okay. Are there any members of the public who are here for this matter and have something that they'd like to have the board consider? If you are, come on up, be sworn, and we'd like to hear from you. Yeah, and this is, we are considering a procedural matter before the board. So if it's just, we don't like how the township has, or the university has used their lights in the past, there may be another forum for that.
Okay.
So right now, it's really dealing with the process of here, whether we should continue the matter this evening. Thank you.
Okay. My name is, okay. Yes, I will.
And state your name and spell it, please.
My name is Martin Caulfield, Caulfield, and I live in the Old Oaks neighborhood, which is directly across Lancaster Avenue, or diagonally across Lancaster Avenue from Villanova University. And I understand you want me to limit it to procedural. And what I would say is I don't think they should be granted an extension at all. I think it should be heard tonight. And I understand what you said. Radnor says they want it, and Villanova wants it. I could tell you, I think that the people on this board have their act together better than perhaps another board within Radnor. And I think that you should get involved. And the comment that Mr. Martin made earlier, I would 100% behind you about why do we keep going on this? Aren't they still doing it? And to make an analogy, and then I'll give you my own story as it applies. When I was in business school, there was a professor who said, beware of the subject matter expert, because the subject matter expert will take a rubber duck and put it in front of you, same type of rubber duck you would find in a bathtub, and he will squeeze the bill of that rubber duck so thin that he will challenge you. Do you know anybody else who can squeeze the rubber duck this thin? And the prof said to us, your job as a manager or as an executive is don't get fixated on the bill of the duck. You say to the subject matter expert, don't you see the tails growing? All right? This is what's happening with this problem. They're fixated on hours of operation. The issue is not hours of operation. The issue is a trespassing issue with light pollution into these neighborhoods. And it's an issue that can be resolved by Villanova simply by using current or even modified technology on their current systems to keep the spill out of the neighborhoods. And I would advocate.
We're getting into
Okay.
the meat of the matter,
Right, but
so
that's
please.
what I'm saying is, the reason for the pollution is the reason why this needs to be resolved right away, and the continuance is just allowing them to continue with the light pollution, regardless of time of day, okay? It happens. As soon as the sun goes down, it's light pollution when they have the lights on into our neighborhood. So that's why I'm trying to say, the reason for I don't see a continuance is, it's not hours of operation. It is light pollution that you're addressing. Thank you.
Thank you. Anyone else?
I do. Anna Marie Hessman, spell both names. ANNAMARIE, space HESSMAN. Thank you. I also live in the Old Oaks neighborhood, and to try to focus my remarks mostly on the issue of the continuance, I think this has dragged on kind of ridiculously. I have a lot of concerns about meetings in the summer. You know, if it were going to be continued, I'd almost rather see it be in September than June. As someone with an August birthday, I'm painfully aware of how hard it is to get anybody to come to anything, particularly in August, but over the summer in general. And I think a lot of the residents, they change their lives for the summer, whether that's a part-time out-of-town experience or a full-time out. That starts in June, doesn't it? I mean, I haven't memorized all of the school schedules, but a lot of people start making changes to their lives in June. So I think for an important matter, to continue it at this point in time for the summer would be detrimental to people's ability to comment on it, although I'm not sure how many people actually were aware that this meeting was tonight. My other concern about people being able to give proper input for tonight is every time I have reviewed the meeting packet, it contained kind of like maybe a 3-page summary. I'm not sure what you call that. It has kind of like a transmittal letter, and it's an application. And that references several documents that are not in the packet. and they've never been on the table when I come in. So that's my other concern about this, and I'm not attached to one specific result, but I think we have some major process problems going on. Thank you.
Great, thank you very much. Anyone else? Okay, we'll consider a motion for the grant of the continuance. Anyone care to move it one way or the other?
I'll make a motion to grant a continuance to the June meeting of the zoning board.
Second? Anybody?
I'll second it.
Board discussion?
I think you've heard me. No, nothing in addition.
All in favor of the grant of the continuance to the June 20th? Yeah. June 20th zoning hearing board meeting, please indicate by saying aye. Aye.
Aye.
All opposed?
Nay.
3-2. The continuance is granted. And we will see you in June. Thank you. Nick, since you're there, on the one thing I neglected on the other matter, where's that number? 3039, that's continued until the May meeting, correct?
Correct.
Okay, thank you.
And I provide a letter with extensions on that. And I
Yes.
will also provide Kevin the appropriate letter with extensions, the appropriate extensions on this matter as well.
Great, thank you. Okay, the housekeeping is now out of the way. We will, we will call appeal.
Can I have 5 minutes or just to talk to the, I think I'm on the next. Is Evans next? I'm sorry.
No, Khan is next. Okay, we're calling appeal number 3037. The applicant, Dr. Mohammed Aslam Khan, property located at 658 Gwynedd Road and zoned R1-DM residential. The applicant seeks a variance from section 280-92A1 to permit encroachment into the 75-foot perimeter setback. And I suspect counsel for the applicant is here. Please proceed.
Good evening, Jamie John here on behalf of the applicant. Jamie, Jamie, last name Jun. We were last before this board in appeal number 3020 to construct a proposed addition to the applicant's home. And we received relief to build the addition within the required 25-foot setback. We were going to infringe 15 feet into the required side yard setback. And after receiving that approval, applicant was working towards getting the necessary permits for that addition. And during that process, the engineer discovered that there is a 75-foot perimeter setback that also applies to this development. We had earlier versions of the plan, and it wasn't clear. There was a note on the side that said that applicable perimeter setback was 35 feet, and therefore we had presented the greater 50-foot front yard setback. But if you
And how was that made known to the owner?
They did a survey, and then as part of that, I believe they looked at the title documents, and there was a recorded plan that actually showed clearly there was a 75-foot perimeter setback. I do ask that the record from the prior appeal 3020 be incorporated into this appeal, but I have provided to the board exhibits A1 through A7, which were all the exhibits that were presented in that appeal.
That's fine, sorry.
Exhibit A8 is the board's decision in that appeal, where basically the board found that under the Federal Fair Housing Act that the proposed addition that we were showing was a reasonable accommodation and that there was no adverse impact on public health, safety, and welfare generally, and also on the neighborhood, as there was a petition that we did provide of neighbors in the immediate vicinity who were supportive of the application. So if we now turn to Exhibit A9, it shows that proposed addition, and that's the exact addition that was previously approved. And there is a red line that shows 63.15. and that shows the dimension from the required perimeter setback. And we're just asking on the basis of the prior approval, again, that we be granted the necessary relief from the perimeter setback as well.
Excuse me, Mr. Chairman. Jimmy, could you put that on the camera? Thank you.
And if you could indicate for our growing number of viewers at home where exactly you are, thank you. Yep.
Shaded on the plan is the addition that was previously proposed. This here is the 75 perimeter setback. So as you can see, the rear portion of that addition infringes approximately 12 feet into that 75-foot rear setback.
Could you help me in reference to A1,
Sure.
showing where the 75 and 63 feet distances are?
You can see in that aerial, towards the rear of the property, there's a wooden deck. And that deck is about 58.89 feet from the street, from Bryn Mawr. So this,
If you could
Yes.
indicate on A9 where that location on A1 is. we
right,
can-
so I
we
am
can
pointing
piece
to
it
the
together.
deck, which you can see on that aerial. And that deck is 58.89 feet off of the right-of-way, Bryn Mawr Avenue. And the proposed addition doesn't extend quite as far as that existing deck. So that is at 63.15.
Okay. Have the plans for the addition changed in any way since we last spoke about this matter?
If anything, it's gotten smaller. There was a little bit of a dimensional mistake that was made by the architects, and I think in order to not increase the relief that this board granted in terms of the side yard setback, it's decreased slightly. I think their measurements for the side yard setback was a little bit inaccurate.
Any other board questions? Okay, thank you. Are there any members of the public that would like to speak on this matter? Seeing none, entertain a motion to consider the relief.
Make a motion that the relief be granted based upon appropriate accommodation to the disability of the resident in the house, consistent with the prior decision that was referenced in counsel's argument.
Second?
I second that.
Discussion? All approved, say aye. Aye. Opposed? Thank you very much.
Thank you.
Okay. Okay, we will move on to Appeal 3038. The applicants, Douglas and Diane Evans, property located at 111 Gallagher Road and zoned C2 Commercial. The applicant seeks a special exception under Section 280-101A2 of the zoning code to enlarge an existing residence in the C2 zoning district. Applicant also seeks a variance from Section 280-52D of the code to construct an addition to square off the existing home, which will extend into the required side yard setback. In the alternative, applicant seeks a variance from Section 280-51 of the code regarding use or such other relief from the zoning code consistent with the exhibits presented.
I am handing up a new exhibit 4A, and I'll explain what it is. Basically, it's the existing plot plan, and we'll show you in a minute. Your old exhibit 4 actually shows what we want. So just by brief opening, this is a property on Gallagher Road. Gallagher Road is, I guess you would say, down Lancaster Avenue going west almost to the end of the township before the Sugartown Road Bridge there. It is actually zoned commercial, although it's been residential from the beginning of time probably. Well, at least the house was built in the 50s, so certainly since that point in time. Actually, back in that period, commercial zoning in Radnor did permit residential dwellings. Now it does not. So it is an existing legal nonconformity. Actually, the Evanses, you'll see they own this site and they own the building next to it, which is also zoned commercial, which they put an addition on that building as well and converted to residential, received a special exception for that. We have the decision, we'll show it to the board. And you'll see it's very attractive, and they're intending to do the same thing with this building here. Interestingly, next on the other side of the Evanses is their daughter now lives there. So they're building a little area there on Gallagher Road, which I don't know if you're familiar with Gallagher Road, is it was part of, I grew up on Morris Road, the road next to it. It was Little Italy back in those days when everyone on both streets were Italian. It's changed a little bit now. Yeah, that's right. Diane's half Italian. So what they're doing here, you'll see they intend to square off, and you'll see it in Exhibit A4, which I'll present to the board. They're intending to add an addition to this building and square it off in this area here. It would go no closer than the existing concrete patio, would be less than 50% additional square footage to the building. So there's two requests for relief here. One request is for the special exception to increase an existing nonconformity by no more than 50%. The other request is to establish the addition 9.8 feet from the property line, which is the property line in common with the applicant. So it'd be no closer than the existing concrete patio that is shown on the plan on 4A. Swear them in?
Yeah.
We do. My name is Douglas Evans.
Diane Evans. Diane, Diane.
Okay, Diane, why don't you step up? There you go. And where do you reside?
We reside next door, 115 Gallagher Road.
And this property is 111 Gallagher Road, right?
Correct.
And during my opening, I said that your daughter actually resides in the other home.
Correct, 117.
117. And actually, we had mentioned before, and we'll present exhibits indicating that you actually did this similar type project on the home where you're currently living.
Correct, yes.
When did you buy the home? I'm going to mark it's A2.
In 2015.
This current home.
This one, October of 18.
All right, and that's marked as A2? October of 18. And I've marked that as A2?
Yes, correct.
Okay. And just showing the area that we're talking about, as we mentioned. So this is Lancaster Avenue, correct, on top of the photo here on A3?
Yes, correct.
And you're back up to the car wash.
We do.
Correct?
Yes, correct.
Pete's Express Car Wash
Yes.
there on Lancaster Avenue. And the arrow points to the home that you're proposing
Yes.
to put an addition on.
Yes,
And
111.
when was that home built?
About 1954.
Okay. And on Lancaster Avenue, is it other commercial property?
Yes.
As well? And it indicates Becker Spa Saloon?
Mm-hmm.
And then behind the Becker Spa Saloon is a parking lot for the Becker Spa
Correct.
Saloon, right? And then also indicating on A3 is the home that you currently reside in?
Correct.
And then across the street from where this property is located, what is there?
Holloway.
It's an office?
Construction.
It's an
Office,
office?
yes.
And then behind Holloway is?
The Radnor Trail.
Okay. And so on the other side of the street, outside of the Holloway building, and there's a commercial condominium, on the corner of Gallagher and
Yes.
Lancaster on the other side. There's nothing, it's just a
Nothing,
trail on that
just a
side of the
trail.
street. But going down Gallagher Road, everything else is residential.
Correct.
Now I'm going to show you what I've marked as 5A. Is that the current home?
Yes, it is.
Okay.
At 111.
That's the one that we're proposing to put the addition on.
Correct.
And that's the front of the home?
Correct.
Then 5B shows the side.
Correct.
And so actually this concrete patio here, I don't know if it shows a picture of it. So you have an existing porch,
Yes.
right? And then you're extending it to where the concrete patio is as well?
Correct.
And that's your fence, right?
Yes.
From the other property. 5C, if you can just tell the board what that represents.
Yes, that is the side of the house that's facing the parking lot.
And then
That is
5D.
the rear of the house, which is facing the car wash.
And that does show the concrete patio on the left, and it shows how your house goes right up to that concrete patio, and the concrete patio is just really an extension of your existing home.
Correct.
On that one, is what is proposed a two-story addition there or one-story?
Two-story.
Two-story, so essentially where the overhang is, then extending to the left where the patio is, and then
Correct.
there.
Now I'm going to show you some photographs of the surrounding area. First, A6, that's the office building across the street.
Yes,
And then behind it is where the trees are, is where the bike trail
the
is.
bike trail, yes. Radnor Trail.
And A7,
That's the car wash
and that picture's taken from where?
from the rear of that property at 111.
Okay, and A8,
That is the side view from 111, the parking lot.
and A9.
That is, that's
It-
the, I don't know.
It shows
It shows
the porch and the
Looking at
patio
our
as well.
property at 115, yes.
Now I'm going to show you what I've marked as A4A. A4A. I believe the board may have an existing, a larger plan on this, but I'll point it out to them. So that cross-hatched area, that's the area where the addition would be going to the existing home.
That is correct.
Now, you're changing the facade of this building, too,
We
right?
are.
Yeah. So
Yeah.
it's not
Well,
just...
we're updating it.
You're updating it, okay. Now, I've marked as A4B, and I'll have to hand this up to the board. And let me hand it up to the board, then I'll ask you what A4B represents.
Why don't you stand up here, because you can help with the...
So, referring to A4B, the first page there, is that the existing square footage of the house?
Correct.
And when you say garage, that garage is located in the front of the home. It's attached to the home, right?
Correct.
It's not a detached garage.
It is not. It's
It's-
attached.
It's right in
It's
this
part of
area,
the
correct?
house.
And so your existing square footage for the house is 1,614 square feet. That's gross square footage.
Correct.
Not just the footprint, but gross square footage.
Yes.
And that actually doesn't include the patio or the porch or anything of that nature, which is really being used for residential purposes too. But,
Correct.
you know, we're within the limit, so, you know, in the abundance of caution, we did not include it. And it shows here on the next page, the existing square footage is being 690, and the garage space is being 312, as we talked about previously, and then shows the second floor as being 612 square feet. Who prepared these plans?
Gosh, our architect, I don't know the name.
Walter and Jackson?
Yes, correct.
Walter and Jackson. And then finally, the proposed new addition would be, or the new square footage would be an
Yes.
additional 580 square feet.
That is correct.
Which is less than the 50% that we're
Yes.
talking about. And as we mentioned, you're intending to cover that existing concrete
That is correct.
patio with part of the addition.
Yes.
To show you what I've marked as A10, and can you just tell the board this, like a rendering, an elevation of the home that's being proposed as well as floor plan?
Yes. I don't know, we're just renovating. I don't.
Okay.
Yeah.
Right. And just, I've marked, she said we're just renovating.
Renovating, I'm sorry.
A13, I've just marked as indicating, as I mentioned to the board, the nonconformity here. It was a business district, and the business district back in 1955 permitted single-family or two-family detached dwellings. Diane, I had mentioned that you received similar relief on the property where you're currently living.
Correct. Yes, we did.
And is that marked as A11?
Yes, correct.
And I've marked as A12. Is this the home that you're living in now?
Correct. Yes, it is. 115.
Are you intending it to be kind of a similar style, or?
Yes. We want to keep it in form of what the neighborhood looks like.
And as you mentioned, and actually, most of the homes have been renovated on the street
They
now.
have, yes.
And we had mentioned it would be similar to this.
Similar, yes,
Okay.
yes. Yeah.
That's all I would have.
Nick, what was the difference between A4 and A4A?
A4 was just the current site plan, and A4A just showed where the addition would go, the cross-hatched area.
Thank
We
you.
had two separate plans. Actually, Kevin suggested that we actually get to show the actual dimensions on where that setback would be, and so that's why we provided that.
Thank you.
What, if any, outreach has been made to the neighbors?
I sent the letter to 200 of our closest neighbors. So everybody received a letter. Yes.
And has anyone indicated to you any discomfort or
Not at all.
objection to the proposal?
I think they're happy that, we're fixing up the house. So, yeah. So we get a lot of feedback from the trail. Everybody loves our house.
Any other questions? Anything else, Nick?
That's all I have, just the exhibits made part of the record, please.
Without objection. Are there any members of the public who would like to speak to this application? Okay, seeing none, I would entertain a motion on the relief requested.
Sure, I'll make a motion to approve the relief requested.
And that would be in accordance with the,
Special exception for the expansion of the non-conforming use and the variance for the side yard.
I would second it.
discussion? Seeing none, all in favor indicate by saying aye. Aye. All opposed?
Thank you.
Good luck.
Thank you.
Moving through tonight, like people know there's an NFL draft. Okay, appeal number 3040. The applicant, Solis Salon Studios, say that 3 times fast, property located at 220 Sugartown Road and zoned C1 Commercial. The applicant requests relief from the maximum sign height of 15 feet from grade as defined in Code Section 280-122C2. Applicant would like to install sign at maximum height of 18 feet. Is the applicant ready to proceed? Okay, great. You are.
I'm John Reinford with LED Experts. We're the sign company. Okay. I do.
Say your full name nice and loudly and spell it for me.
John Reinford, R-E-I-N-F-O-R-D.
Mr. Reinford, I'm sorry, before you go further, is there someone from the applicant itself that's here?
Yes, Solus. Yeah.
Okay, would you please be sworn?
Robert Bruner, Robert, Bruner, Breuner, owner, operator, Sola Salon Studios.
Thank you.
We went to the Design Review Board meeting in March, and were approved for our design with the condition that we needed to get it. Oh, okay. Sorry. We went to the Design Review Board meeting in March, and were approved for our design with the exception that we needed to get approval from the Zoning Hearing Board to be 18 feet above grade as opposed to the limitation of 15. If you look, we're taking the spot in the plaza that has the large marquee, as opposed to the other plaza tenants have the lower wall. They don't have the large marquee. So that's why we want to move it up 3 feet higher than allowed. And you can only see in this picture here, you can see the other tenants that are 15 feet there is the maximum for those.
Okay, I'm going to take care of a little housekeeping here. If you, for the record, which is a written record as opposed to anything else, we need to identify the particular exhibits you're referring to
Okay.
in the course of this testimony. So, starting from the upper left, is that the page that's indicated page 1 of 3?
Yes.
Okay. That will be, page 1 of 3 will be indicated as, let's go with the application itself as A1. That photograph or rendering, excuse me, as A2. And then page 1B of 3, which is, I believe, to the right of that. Is that correct?
Yes.
Okay. What is indicated as page 1B of 3 will be exhibit A3. And then, I guess, the rendering itself of the logo, which is the stylized Solus Salon Studios exhibit, will be A4. Okay, so I apologize for that inconvenience, but we do need.
This one page? Page
Well,
1C of 3?
well, he's only got 3 up there, so.
Together.
Oh, I'm sorry. Oh, okay.
Yeah, you want to keep it,
Oh, okay, I'm
Want
sorry.
to keep it in order?
Yeah, okay. All right, then let's scratch that, Norma. We're going to, there is a page 1C of 3, as George indicates. That will be A4. Solus Salon Studios, stylized logo will be A5. I don't think we really care about the attachment detail. Okay. Thank you. Sorry.
No, that's-
A little housekeeping. Proceed, I'm sorry.
So, I mean, that's our request, is to get approval for
I'm
the
sorry,
sign.
you have to speak up, I couldn't hear.
Our request is it on?
may not be on.
Speak loudly right into it.
Our request is to allow the sign to be permitted at 18 feet in height as opposed to the zoning 15 foot of maximum.
So the first question naturally is going to be why?
I can take that. So-
Oh.
So what our business does is we provide space and help beauty professionals operate and start their own businesses. And our goal is to have a very professional setting. So we'd like to take advantage of this area to have a little more professional sign than would otherwise be a backlit channel, 15-foot, franchise sign.
And as you can see in this, the previous sign.
I'm
was at
sorry,
the-
microphone.
The previous sign was at the 15-foot maximum.
Sir, use the podium mic.
The previous sign was at the 15-foot maximum of the previous tenant, and as far as, aesthetics and professional looking, that we didn't, that's really wasn't good.
Well, luckily, we're not, you've already been to the aesthetics guys. The design review board can weigh in on whether it looks good or not. My first question is why that's any more effective than the Dan sign just to the immediate right of that would be, which I believe is down at 15 feet.
Yes.
So,
Well, the
Uh,
difference being that we have the big marquee to use, whereas the other tenants don't have that, so it doesn't, they couldn't really go higher than 15 feet. I mean, if the building had the architecture and aesthetics to include this in the design, so we're asking permission to actually use the aesthetics of the building.
and one of the challenges when applicants come before us is, and one of the things that we predicate a grant of relief on, is there being some sort of a hardship. And is there some argument you can make that there is something unique about the nature of the property where you want to use this sign that makes it, that is sufficient for us to grant a variance from the other, for instance, the other, and this is the shopping center that cuts into Tredyffrin, right? I mean,
Sugartown.
Yeah, right. There are other stores with signs at 15 feet. What is it unique about the nature of this property that really mandates that an 18-foot limit is what you need? Other than you think people will see it more readily and you have a big facade that you want to fill up with the name of the business.
Yeah, absolutely. And that would be that we have the 3 continuous bays, and we're taking all 3 of those bays, what would be to the left of that marquee. And so we're utilizing our maximum amount of signage for those 3 bays and positioning it in the middle of that marquee for a very professional looking sign that would otherwise be much too small at the under 15 to even really be effective at marketing at all.
How much space is there between the bottom of the S and the facade if you moved it down 3 feet? Same size, simply drop how high it's.
Yeah, we have that.
Or top picture in A4.
So if you move it down, you'll see if we move it down to the 15-foot limit, the sign goes off the bottom. And then I also did a rendering of a 15-square-foot sign as opposed to the allowed 50-square-foot sign at 15-foot maximum. And it just looks bad and ineffective.
Is this a lit sign?
Yes, it's illuminated channel letters, face lit and a halo lit.
And is that on 24/7 or?
It'll be on a timer, so it'll go off. I think there's a limit for the plaza, 10 p.m. or I'm not 100% sure on that.
About how far is the facade from the public road?
Oh, it's more than 150 feet, I would guess.
So you would argue that one of the peculiarities of this property is its distance from the public road, making the 15-foot height problematic to be seen by people out on the nearest public road.
Yes. Thank you.
What's your impression of your neighbor's sign to the right when you see it from the road?
The neighbors to the right also have a larger sign around the side of the building. That's a corner area that they have that actually is partially, I think, can be seen from Lancaster Avenue. And it's got a symbol that is over the top of what would be that Dan signage right there.
Not in the picture.
Any other questions from the board? Okay. Traditionally, you would now move your exhibits to be entered into the record. You would ask us to do that, and we would say yes, so,
Would ask that our exhibits be moved to be entered into the record.
without objection. Are there any members of the public who would like to speak on this matter? Seeing none, can we get a motion to consider the relief requested?
I'd make a motion that the requested variance be granted consistent with the plans and the exhibits submitted at this hearing.
Second?
I'd like to second that.
Any discussion?
I think, I still think that when things are not unreasonable, we need to go out of our way to help retail locations, because I just think that if somebody wants to open up a store and pay taxes, that we should be trying to give them the benefit of the doubt.
Agreed.
All right, call a vote. All in favor of the application requesting the relief, indicate by saying aye.
Aye.
All opposed? Good luck. Thank you.
Thank you very much.
And we're adjourned.